Member for Burnaby Lougheed.
Thank you, Mr. Chair. So looking at Section 1 of the bill for the definitions, for the franchise agreement, it reads that the franchise agreement means any agreement that relates to a franchise and is entered into between, and it goes on. I'm just wondering about the generality in the wording of any agreement. If the minister can please comment on any potential point of concern right there. Is it referring to verbal agreement would be considered sufficient as far as franchise agreement is concerned? Should it be written? Should it have any legal context or framework around it? So if you can just comment on what we mean by any agreement and what would be sufficient definition for that, that'd be great.
Minister.
Thank you very much, Honourable Chair. I'm sorry, we had problems hearing the question. Could I kindly ask you to
Absolutely.
Member.
Okay, sorry about that. No, it's under definition for franchise agreement. It reads that it means any agreement, and so I was hoping for the minister maybe to supply the House with a comment on whether that generality is intended or if there's any need for further specification, because it's unclear at this point if even a verbal agreement would be considered sufficient as far as this franchise agreement is concerned. Does that make sense? No?
Minister.
Thank you very much, Honourable Chair, and thank you to the member opposite for the question. The definition is broad by definition, and it aligns, it closely conforms with the definitions in the Uniform Act. And the provisions matches the legislation in Alberta, Manitoba, Ontario, New Brunswick, and PEI in order to provide certainty and clarity for both franchisees and franchisors operating franchise businesses. And so, and then as you go into, we describe that as we go through the rest of the Act.
Member for Burnaby Lougheed.
Thank you, Mr. Chair. And I will move on to other definitions. I was looking at the definition for franchisors associate, and in that, in subsection B, in the second paragraph, it goes on to say that the franchisors associate is a person who exercises significant operation control over a franchisee and to whom the franchisee has a continuing financial obligation in respect of a franchise. But I was just noticing the difference between how there's an omission of the franchisors associates responsibility, so to speak, in that in the previous definition for under franchise, you see that in subsection A.2, there's a second point that's being made that a franchisor or the franchisor's associate exercises significant control over and or offers significant assistance for the franchisees. So I'm curious to find out why that omission is there between the definition that we see for the franchisor's associate under franchise versus the franchisor's associate definition as it stands that we see in that subsection B.2.
Minister.
Much, Honourable Chair. There are actually two different applications in the Act.
Member for Burnaby Lougheed.
Thank you. Now going on to the definition for franchisor's broker, I'm just a little curious about the actual difference between the franchisor's broker versus franchisor's associate as it's how it reads in the Act, because as far as the main definitions go, both the broker and the associate seem to be granting, marketing, or otherwise offering to grant a franchise. I was curious to find out then if clarification can be afforded in the House. Can the minister just confirm the fact that perhaps maybe the only difference between an associate and a broker then is really the broker won't be reviewing and approving the grant of the franchise?
Minister.
Thank you very much, Honourable Chair. The franchise broker is more of an external role, so they're less likely to be involved in the actual sale, whereas the franchise associate is more deeply related to that. And as to the question that you had, the courts would determine that.
Member for Burnaby North.
Thank you,
Burnaby
Mr.
Lohied,
Chair.
sorry.
Thank you. Now, if we can get the minister's attention to the definition of misrepresentation. Obviously, the definition of misrepresentation is an important one because it is the ground on which franchisees can often exert their rights against unfair dealings. So when we're looking at misrepresentation, I couldn't help but notice, of course, that it reads subsection A, untrue statement on a material fact or an omission to state a material fact. And of course, given that material change can occur during negotiation, not necessarily always after, and given the significance of a material change, I'm curious to hear from the minister about the omission of the material change not being included in the misrepresentation definition.
Minister.
Thank you very much, Honourable Chair. They're completely two different definitions. So the misrepresentation relates to a statutory remedy, and material change relates to disclosure obligations.
Member for Burnaby Lohied.
Thank you, Mr. Chair. And going to the definition for franchise system, for subsection D, the goodwill associated with the franchise. So I would like to ask the minister about the definition of goodwill. Of course, as it turns out, somebody actually pointed this out to me, that there's two definitions of goodwill. One is friendly, helpful, or cooperative feelings or attitude. And the second one is the established reputation of a business regarded as actually a quantifiable asset. So there's a difference between something that's a good gesture versus something that implies a quantifiable asset that can be asserted. And I appreciate that there's a great amount of generality on the use of that term goodwill, and a broad definition is useful. But given that there is such a big spectrum in the definition or the particular choice of that vocabulary, can the minister please clarify to what extent can we interpret the latitude that's associated with the vocabulary goodwill?
Minister.
Would be a quantifiable asset. Quantifiable asset, your second definition?
Shall section 1 pass? So ordered. On section 2. Shall section 2 pass? So ordered. Shall on section 3, member for Burnaby Lohied.
Mr. Chair, for section 3, fair dealing, the three subsections all refer to a party or each party. So is it correct for one to assume, because it doesn't necessarily read it in the act as we have it, that when we talk about the parties that are involved, it actually specifies the franchisor, the prospective franchisee, the actual franchisee, the franchisor's associate, and of course the franchisor broker. Can I assume that that is the case for all 5 parties to be involved?
Minister.
Chair, all parties who have signed the Franchise Act, it relates to the good faith and fair dealing.
Member.
Just to clarify on the minister's answer, did I hear her correctly that only those that sign on to, she referred to the act, so I'm just a little bit confused if she means the act or the agreement.
Maybe both can speak a little bit, they're very soft spoken, each side. Can't you? Thank you. Minister.
Thank you very much, Honourable Chair. I stand corrected. I am sorry. It's franchise agreement. Thank you.
Shall section 3 pass? So ordered. Shall section 4 pass? Member for Burnaby Lohied.
Thank you, Mr. Chair. Moving on to section 4, the right to associate. The right of association is a very fundamental one, to be able to join or leave groups of one's own choosing, and for the group to be able to take collective action to pursue the interests of its members against often a much larger entity of greater power and resources. So this particular section is not just a welcome one, but a very important one in this act. And the subsection 5 does read, if a franchisor or a franchisor's associate contravenes subsection 2 or 3, a franchisee has the right of action for damages against the franchisor or the franchisor's associate, as the case may be. But of course, we all know that in reality, the franchisees are largely unaware of the fact that such right is now, of course, legislatively empowered for them to exert. And even if they knew, of course, their legal literacy as well as their organizational capacity is often very greatly limited to pursue their right of action for damages against the franchisor, should they contravene this particular section. So I'm hoping that the minister can maybe talk a little bit about how the government, what would be the government's role to make sure that this particular provision is reinforced, and that what kind of educational efforts will be afforded by the government to ensure that that this law is well understood by the franchisees and that they'll be fairly protected.
Minister?
Honorable Chair, we will be producing an information guide that will ensure that, and is a guide that will be distributed on our website, as well as we'll be reaching out to the advisory group. They're very excited about the opportunity to be talking about these important changes. So we know that on the professional development side, that they will be, they're excited about these changes. And finally, we'll ensure that through our small business ministry that we circulate it through the different associations.
Member?
Thank you, and thanks for that answer. And just as important as it is for the franchisees to be aware of this, will there be a communication strategy to make sure that the franchisors or the parent companies will have easy access to the changes that are brought in?
Minister?
Thank you very much, Honourable Chair. The Canadian Franchisor Association was out in British Columbia we've had those discussions with them. They're very supportive, and I know that they'll be circulating that information, the changes as well through the franchisor community.
Member for Vancouver Kingsway.
Thank you. This section 4, is an interesting section of the legislation in that the principle of fair dealing applies to a lot of the detailed regulation of the relationship between franchisors and franchisees that might exist. In general, those have been covered in Section 3 by fair dealing. However, the government and other Canadian jurisdictions have chosen to be specific in this case. I mean, violating someone's right to associate with other franchisees might in principle be considered to be interference or not fair dealing. I think that would be a fair person would conclude that. However, the government has chosen to explicitly address this question of the right to associate in the law. So I wanted the minister to describe, because it seems to me that we've run into these cases, of the problem that the government is choosing to address here. In other words, is it the case, and is the government aware of examples of franchisors trying to limit the ability to associate or the right to associate of franchisees?
Minister.
Honorable Chair. Again, this section is consistent with the Uniform Act, the legislation, and really what it is designed to do is really to protect the ability for franchisees to have that conversation. And we know how critically important it is to be able to have that open dialogue, and to form an organization is a means of reducing the power imbalance. And that's the whole strength of this legislation. So this provision is similar to the 5 other franchise statutes across Canada, and as like I said earlier, is consistent with the Uniform Act.
Member.
Minister, aware of case in British Columbia where franchisees have been denied the right to associate?
Minister.
Thank you, Honorable Chair. We did hear through consultations that franchisees that they had identified that there was a problem, and the BCLI through consultations also heard that. The challenge on this particular issue is the sensitivity around the franchisees coming forward wish to remain anonymous.
Member.
Thank you. And I wanted to ask the minister whether, in her view, this provision, because it doesn't include a prospective franchisee, whether this provision would apply to a prospective franchisee. Because, you know, in effect, that is, it's not the only key moment, but it is a key moment. If, for example, when we're, I was going to name a franchise operation that's only in Ontario, so it wouldn't affect us here, but let's say franchise A, and you are thinking of getting involved in franchise A, and you're a prospective franchisee, you haven't signed the final agreement, but you want to talk to existing franchisees, right? And you're given a list of them. In fact, under the disclosure provisions, you're given that list. The protection isn't for the prospective franchisee, but for the franchisees who would be asked questions that would be really significant. I mean, the franchisor is trying to sell to the prospective franchisees. The other franchisees have a business relationship with the franchisor. Is this right to associate extended to a prospective franchisee in those circumstances, and should it be?
Minister.
Thank you very much, Honorable Chair. Section 4 only is in reference to a franchisees, as we described before, and that's somebody who has signed a document or has put money down on an agreement. But there's nothing that would suggest or govern the suggestion that prospective franchisees could not go out and have a conversation with a franchisee.
Member.
Oh, except I guess, Honorable Speaker, Honorable Chair, that we're passing a law that says a franchise may associate with other franchisee, a franchisee may associate with other franchisees, may form and join organizations. A franchisor and a franchisor's associate must not interfere with, prohibit, or restrict by contract or otherwise a franchisee from associating with other franchisees. So those provisions and those that follow from them are guaranteed in the law. What's not guaranteed in the law for a prospective franchisee is that same right. In other words, the government has chosen to protect that right, and presumably other governments, and I understand the need for uniformity, but we've defined prospective franchisee here in the Act, and it's at that time surely that your right to associate is in a way it's most important, right? It's true, I suppose, you could fall back on the law of fair dealing again, in that case, that it would not be fair dealing for a franchisor to interfere in that right, but you're not specifically prohibiting it here. So I guess I'm asking whether what would be wrong with prohibiting franchisors from interfering with a relationship between franchisees and prospective franchisees.
Minister.
Very much, Honourable Speaker. The member opposite is correct that it doesn't govern prospective franchisee.
Member.
Correct. That really isn't an issue. Honorable Chair, I think the question is whether it should be the case, right? Because this is an important moment in the relationship. You could argue, if you were the minister, I suppose, that the relationship is slightly different. In other words, there may be commercial activities otherwise governed that franchisees who both have existing arrangements are different than prospective franchisees. But presumably an act that gives primacy to disclosure wouldn't consider that important. So I guess I'm asking the minister on this section, section 4, why the right to associate in section 4 wouldn't be extended or shouldn't be extended to prospective franchisees. It seems to me, given the definition of prospective franchisees and the importance to the decision of having access and ability to associate with franchisees for a prospective franchisee, why wouldn't that also be guaranteed in the law, other than the sort of self-explanatory reason that, well, it's the same as the other acts? Why would it actually not be a good idea to include that?
Minister.
Thank you very much, Honorable Chair. Through you to the member opposite. The prospective franchisee has different interests than the franchisee. They have, up to this point, have not put any money on the table. It's more of an exploratory discussion, and there's been no commitment made. And so this is a policy decision that this act is between a franchisee and a franchisor, and we've defined a franchisee as somebody that has committed by signing an agreement or by putting money on the table. But Honorable Chair, I will say that just because it's not governed within this act, it certainly doesn't preclude a prospective franchisee from having that conversation with other franchisees.
Member.
Well, of course, we'll get into Section 5 in a little while or later on in the debate. But of course, Section 5, the section around disclosure, is very much centered on the question of the prospective franchisee. No, we're not. We're on Section 4. And so on Section 4, I guess one argument that might be used is that the result, subsection 5 of Section 4, indicates that you'd have a right of action for damages, which as a prospective franchisee you wouldn't have, because presumably there wouldn't be any damages. You haven't signed an agreement yet. But I guess the interests are different, but they're not more serious. So I guess the first question I guess I would ask the minister is, informing this, does she think there should be any impediment to the right to associate with franchisees for prospective franchisees who are about to make a very significant life and business decision? In other words, would she see it as contrary to the government's view of the Act for franchisors to exercise any influence over the right to associate of a prospective franchisee with existing franchisees?
Minister.
Very much, Honorable Chair, and we want to have the opportunity to have a thorough discussion about this because, Honorable Chair, we do feel that there is a difference between a prospective franchisee and a franchisee, that there is different levels of seriousness. And again, going back to the definitions, a franchisee has put money on the table. A franchisee has made a significant commitment. They've signed a document. And if you look at a prospective franchisee, it's an exploratory relationship that is being explored. And so, once you sign a document as a franchisee, you've entered into a legal relationship. And within this section, the right to associate, it is a policy direction. It's a policy decision that we've made, to be uniform to the 5 other statutes across Canada. And it's also, a policy decision on how prescriptive you are when it comes to making statutory requirements. And in this particular case, again, if you look at a prospective franchisee, we feel that it being governed by the idea that you sign a disclosure document, you sign a contract, you go to the bank, you financially put money down is significantly different with that. But I'll go back to what we also said, that while this is an act that refers to the relationship between a franchisor and a franchisee, there's nothing within this section of a right to associate that would stop a prospective franchisee from having a conversation with the franchisee.
Member.
Well, I would hope there's nothing in a section entitled Right to Associate that would deny that. I mean, I think that's self-evident, but obviously there is a difference. And one of the differences that the minister is saying that exists is the rights to associate of a franchisees are superior to the rights to associate of a prospective franchisee. That's what the government is saying by not including a prospective franchisee in this section. I mean, a prospective franchisee is someone waiting for a disclosure document, for example, who is initially indicated, so they're significantly down the road. They're not just someone who's walking, driving past a Wendy's and saying, what if? They actually are in the process of an agreement. They're still a prospective franchisee. And so I guess it seems unusual that one of the differences the government would define between franchisees and prospective franchisees, it affects their right to associate, which most people would argue would be a fundamental right in a democratic society. So, and moreover, the person in that period, in other words, in the period where they are receiving a disclosure document and are a prospective franchisee, that that period is a period where the right to associate is important. In other words, I understand that the right to associate of franchisees amongst themselves doesn't take away from their right to associate with prospective franchisees, but it's also not guaranteed here. And the explanation as to why seems to be, kind of opaque, that we don't. And so I guess what I'm explicitly asking the minister is, notwithstanding the fact that the government has chosen not to include, not to believe that the right to associate prospective franchisees should be guaranteed in the Franchise Act, does she think there should be any limitation on the right to associate of prospective franchisees with franchisees?
Minister.
Thank you very much, Honorable Chair. This is, to the Honorable Member opposite, this is a commercial relationship. It's not a labor relationship. And that I would remind the member opposite that what was very clear in all of the consultations and all of the discussions that we had with the advisory group, that the significant piece of this act is about the uniformity and the fact that we are ensuring that we are consistent with the other statutes in the other provinces to ensure that uniformity, and that is on the right to associate. It matches with Uniformity Act.
Member for Cell Session 4 pass. So order. On Session 5.
So for Section 5 on disclosure, sorry. Thank you, Mr. Chair. So on Section 5 for disclosure, this is the largest and the most complex section of the bill, requiring the disclosure by a franchisor to the prospective franchisee of the financial information and other relevant information so that the franchisee can make an informed decision. So now this section also does include the requirement for material change in subsection 6. And although I do want to mention one more time that the need for the material change is omitted in the definition in section 1 under misrepresentation, but nonetheless, section 5 is an important section in protecting small businesses and prospective franchisees and helping them make an informed decision. So again, my question to the minister is similar to the one that I posed to her for Section 4. I'm curious to find out, and of course, if the minister can elaborate a little bit more as far as the information campaign to ensure that these provisions are reinforced or are enforced. Can the minister explain a little bit about what kind of staff and, of course, budget allocations and what performance indicators will be in place so that maybe in a year's time that we can have a chance to review how effective the information campaign by the ministry would be. And another consideration is, of course, given that many of the franchisees and the prospective franchisees, and as challenging as it is for us to navigate through the legal language of an act, will there be a commitment from the government to make available some of this information in, of course, simpler languages and also in other languages, be it Chinese, Punjabi, Korean, so on and so forth?
Minister, and noting the hour.
Thank you very much, Honorable Chair. Really what this section and this act is, in fact, it's setting a framework for a relationship, from legal framework to provide franchisees with the ability to guide that relationship and to ensure that we're leveling that playing field. And we will be monitoring the effectiveness of this and will be guided by the best practices of other jurisdictions.